So we're in our government book. We're in Unit 3, the last unit, and we're going to begin this unit by talking about American federalism. And then we're going to go on to Chapter 11, which is the state and local government, onto an American citizen in action, making a difference. So this chapter has to do with American federalism. So we're going to find out what it means by the word federalism and how do we split the government between the national government, the state government, and local government. And what does that mean? So Chapter 10 on American federalism. I like this saying by James Madison, and he wrote this in the Federalist number 45. And he says, "The powers delegated by the proposed Constitution to the federal government are few and defined, and those which are to remain in the state governments are numerous and indefinite." So what he's saying is that the federal government, which is really our central government, the national government, we call it our national government or our central government or our federal government, that basically the powers of that are few compared to the powers that are given to each state government. We have 50 states, and each one of them have their own government. And then, of course, the local governments are the different cities and county governments, and we'll go into that too. But what he's saying is the federal government, the central government, actually should be few. The powers should be few compared to the state government. James Madison was really a proponent of states' rights. And he was actually one of the writers and formers of the Constitution, right? The founders. So let's go on and see what basically Chief Justice Morrison Waite said in 1878. So this is, in the beginning. When we think of 1878, well, actually, it's about 100 years from the beginning. So, one branch of the government cannot encroach on the domain of another without danger. So, the safety of our institution depends in no small degree on the strict observance of this salutary rule. Okay, what he's saying? He's saying that we have how many branches? We have 3 branches of the government, really, and one cannot encroach on the power and the domain of the other without danger. They all have to balance out in their checks and balances, and we learned about that. But also the safety of our institution depends no small degree on the observance of this rule, when it comes to balancing, and we're going to talk about the balancing of powers between the federal government and the state government. So the highlights, we're going to talk about federalism here first, and on to the Constitution and federalism, and the history of federalism, the rise of the central power, and federalism today. So this video, we're going to basically talk about federalism and what it is, and a division of power. So federalism defined. So let's say, well, the United States, first of all, the United States is a what? And you need to know that. It's a constitutional republic. We go by a constitution, but a republic basically is representatives, right? So representatives and by a constitution. So this federal republic, we know it's a federal republic. It may be also described as a federal republic. The term federalism, what's the term federalism? It has to do with the division of power among the governments within a nation. So federalism means basically the powers are divided. So how are the powers divided? Most nations divide their power between central government. Basically, when you talk about a central government and local governments, they're 2 different things, right? So there's actually 3 different types of so-called governments. And these 3 types of modern governments today are, first of all, the unitary system, the confederate system, or the federal system. So these three that we're going to talk about. You rarely hear these words, but we know there's three different types. A unitary system. So what's a unitary system? Is basically when the central national government, the central power of the government, possesses all the power through local governments, basically power over local and state governments. And most countries have a powerful central government that is actually controlling the other governments, like Great Britain, France, and Israel. All have a pretty much central government. Confederacy, the local units possess all the political power. So the political power basically is stronger in the local units than it is in the central government. And a confederacy usually is pretty weak. A confederacy basically means a friendship between. So when in the United States, when we actually had a confederacy under the Articles of the Confederation before the Constitution, and basically saying we are a bunch of states together, and each state possesses power, and we're just hooked together with a friendship. And our union, our central government is not as powerful as our state government. Also, during the Civil War, we talk about the Confederacy of the Civil War, and basically at that time, those states who had withdrawn from the Union during the Civil War had their bondage together as states in a friendship type and not a strong central unit. Okay, so we're going to see this better in just a little bit. Here's a picture of it. So let's look. So here's how big this is a unitary government. It's where the central government has a lot of power, and then the state and local governments have little power, and unitary government controls. Here's the Confederate. It's actually where the state and local government, right here, the bottom here, state and local government have the power, and they give some power to the central government. It's just the opposite of this. These two are opposite. See how the state and local government at the top, and then the central government. So this is bigger. The federal government is when each is the same. And this is what we say we have is a federal government. We have the central government is strong, but also our state government is just as strong, equal. So this means federal. So unitary, confederate, and federal. Unitary is when the central government, unitary government is stronger. Confederate is when the local and state governments are stronger. And federal is when they are equal in power. And so basically, simply stated, a federal system is one that divides political power between the national government and the state governments. And the United States has a federal system along with, Germany, Canada, and Australia, I should say. Australia. They all have a federal government where the state government is as strong as the central government. Okay? So let's go on from there, and as we go, you'll see more. But this basically is very good to show you the three different types of government, and we have equal, so you'll know that. So federalism, the founder's choice. Why did our founders and writers of the Constitution choose a federal republic? Why do you think? First of all, they did not want to have a monarchy with a king at all. In fact, we had to declare the Declaration of Independence from George III of England, who was controlling. They did not want basically to have a dictator or a king or a monarch in that way controlling our country. The reason they chose the federal system was because of their belief in biblical teaching of fallen man. I love that, because you always thought, why would they want to divide the powers between the federal and the local government? Because they knew. What did they know? They knew the Bible. And what did they know in the Bible? Well, they knew that man has a sinful nature. The heart of man is deceitfully wicked beyond measure. And so in knowing this, and in knowing the Bible, they knew that there had to be strong checks and balances in the government. It'd be a strong state and a strong federal could balance each other out, and one wouldn't be too strong and overcome the other. Because of their belief in the Bible, teaching a fallen man, that man has a sinful nature, they picked the federal organization of government. Whether the government be vested in one individual or a small group of men or in a mass of people, it'd be basically unbalanced power. So sinful human nature makes the concentration of power a dangerous thing. So whenever you have the concentration of power, then it becomes dangerous because mankind, in that taking over that concentration and not balancing each other out, that takeover from power can cause major problems, of a certain person or a certain group taking over the country, right? They were convinced political power should be divided. And so here's what James Madison said again. He said, ambition must be made to counteract ambition. So ambition must be made to counteract ambition. To counteract the ambition of sinful man is to force his selfish will on others. The founding fathers created a form of government in which the political power did not rest in the hands of any one person or any group of people. So the powers would be divided among different levels. Now, the powers would be divided between the national level, our central government, and each state government, and also the local governments of the local cities and local towns. So basically saying that this would balance out the powers, because so that one power wouldn't take over, the other power. And that's just because you don't want any power taking over because of man's sinful nature. What would happen? Yeah, what could happen? Yes, we could end up with an evil government taking over and having the ambition of being a dictator in some way. So that's why they chose the federal government, to equal things out. So now we're a nation of many governments. I like this part because the founders of our Constitution and founders of our country understood human nature, that we now will have many governments in the United States. In fact, all of the organizations of governments add up to what? 85,000 governments in our country. Why do we say 85,000 governments in our country? Because we have, 50 states? Well, how many counties do we have in our country? How many towns do we have in our country? How many cities do we have in our country? How many districts do we have in our country? If you add them up, it's going to be more than 85,000. So we have lots of different governments in our country. And of course, we have the national government, which is in Washington, D.C. And each of these governments have their own characters and their own powers and their own responsibilities. So we have these thousands of governments in our federal system, but if you look at the totality of all of this, the Constitution only mentions 2, not 85,000. So the 2 that the Constitution mentions is our central government, which can be called our federal government, the federal government or our central government, and that's in Washington, D.C. with the Capitol building there. And then our state and local governments, which are all the other thousands of governments that are all in one, is our state and local. So the Constitution only mentions 2. So even though there are many more, is grouped into two groups, the central government and the state and local government. The Constitution and federalism. So there are clear distinctions between our national and state government in the Constitution. Here's James Madison again, Federalist number 46. He says, the federal and state governments are different agents and trustees of the people, constituted with different powers and designed for different purposes. So the federal government is designed for a certain purpose, and the state government has different powers than the federal government and has its perfect purpose. So both of them will balance out, but they both have different purposes and powers. Let's go on here. We'll skip this article and go back to it. The federal principle now is the cornerstone of our constitutional republic. This federal principle, when you think, what is the federal principle? Basically, the dividing of power between the central government and our states. When you pay taxes, you're going to pay taxes to the IRS, which is basically the internal revenue, and we pay taxes to our federal government. You're also going to have to pay taxes to the state of California or whichever state you're on. So these are the two divisions between the federal and the state. So the federal principle is the cornerstone of our Constitution republic. It balances the power out between the federal government and the states. And it's also a restraint against tyranny for us to have basically a strong ruler ruling over with the central government and controlling everything. It also preserves our rights and liberties as citizens too, as rights and liberties from the local to the state to the central government. So incorporated in this principle is by dividing the power between the national and the state government. It's important. It says here, the founders incorporated this principle in our Constitution in two ways. Number one, by dividing power between the national government and the state governments, and also by describing the obligation that those governments must accord with each other. So the Constitution divided the power and also stated the obligations, or what the state's power would be and what the central power would be. And it's described in our Constitution. So dividing the power. Here we have printing currency is the implied power of Congress. We're going to talk about these powers. So dividing the power. So the power is denied. There's some powers that are denied to both governments. Neither one of them can do it. What are these powers listed in the Constitution that limit these governments? First of all, neither states nor a central government can pass bills of attainder of ex post facto laws, and neither the states nor the government can grant titles of nobility. Those are two things. So ex post facto means after the fact laws, and we'll find out those ex post after the fact laws that they make after it's been done, and we'll get into those later on. I'm not going to get into those, but that's one thing that the states neither the states nor the central government can do. And there's power that's denied just to the states. The states can't do. And some of these powers is a state cannot coin or make money, right? They cannot coin money, or they cannot, also when you coin money, that means they cannot print up money, right? And so a state also cannot enter into treaties with foreign nations, right? And they also cannot, the impairing of obligation of contracts, they can't make contracts an obligation. They can't make compacts with interstate agreements without Congress approval. They can't make a compact between their two states. Say, we're going to make a compact between the state of California and Nevada without the national government being involved. So those powers are denied to the states. There's also powers that are denied to the national government. So the national government, couple of the things listed, they prohibit from requiring a religious test for office holders. So basically, they can't give a religious test because basically the power of the state and religion. We went over that before. They cannot lay duties on items exported from any state. So when states are exporting, they cannot lay duties between those states. And they basically cannot bring forth cruel and unusual punishment. All of these kind of are in the Bill of Rights. And we're going to go over, we've gone over the Bill of Rights, and we'll go over these powers. The powers exercised by both governments. So there's powers that the state has and the national, and these are called concurrent. Concurrent means they involved both. They're concurrent in both of them. So concurrent powers, both the states and the federal government have a right to tax us. That's why you get a state tax and you get a federal tax, and you have to pay those taxes. So the power to tax and the power to borrow money. States can borrow money, and also our central government can borrow money. So that it has to do with economy a lot. Power to tax and the power to borrow money. And then there's powers granted to the national government alone. And that's power to regulate interstate commerce, to regulate commerce between states. Also, the power to declare war for the United States is our national government. A state cannot declare war on a foreign country. Only our government, our central government, federal government can declare war. So we have now what's called, and this is a picture of it, we have what's called expressed powers and implied powers. When we talk about these two words, expressed and implied, we talk about expressed as being, it's expressed in the Constitution. The Constitution just says it right out that they have this power or don't have this power. And then we have implied powers, and those that are implied by the Constitution but not expressly stated. And those have to do singular for certain, like here's one basically saying the printing of currencies implied power, because in the Constitution it says that our federal government can coin money. It doesn't say print currency, but it says coin money. Well, as time went, currency came in under, printing money and making coins is the same thing. So they said, okay, that's an implied power, even though printing currency doesn't say, printing currency is not said in the Constitution specifically. Now it's implied. So implied is from the Constitution that depends on the interpretation of judges. Before you can have an implied power, the Supreme Court has to say, yes, these are implied powers. So that you can't just imply them, but the Supreme Court needs to interpret to see if they are implied powers by the Constitution. So implied powers are not just stated in the Constitution, but are implied in the Constitution. So I hope you got that. I hope I explained that right. So just know the difference between expressed powers, those that are in the Constitution, and implied powers, those that are implied. So, okay, let me go on to the next here. I have to go on to the next page. So, expressed and implied, just remember the coining of money, and now currency is not mentioned, but now a Supreme Court ruled that currency is implied power to coin money, the same thing. The basis for implied powers is in Article 1, Section 8, Clause 18 of the Constitution. And this is what it says, so you know where this comes from. It's very important because it comes from our Constitution. So it says in our Constitution to make all laws which shall be necessary and proper for carrying into the execution the foregoing powers and all other powers vested by this Constitution in the government of the United States or in any department or office thereof. So, the whole key for this whole, what it says right here, is the words necessary and proper. It says basically the Congress shall make the laws which are necessary and proper for carrying out or executing these powers. This is a big thing, because now Congress thinks, well, we can do a lot of stuff. We just need to do what's necessary and proper. That necessary and proper clause now give Congress a lot of elasticity. It's called it's basically called the elastic clause, because they can stretch this necessary and proper to a lot of different ways in which they want to do it. And necessary and proper, though the founders meant necessary and proper, mean it still had to do with the Constitution. They couldn't just stretch it into fitting, right? But they do. So, for carrying out into execution those powers that are vested in the Constitution by the United States government. Okay, let's go on. There's a Supreme Court went through this whole thing. The Supreme Court established the doctrine of implied powers, necessary and proper powers, in the landmark case of McCulloch versus Maryland in 1819. So we're thinking the 1800s, early 1800s. So what happened here? Well, the state of Maryland tried to tax a branch of the National Bank. And the cashier then refused to pay the taxes. His name was James McCulloch. And it was in Maryland. He refused to pay the taxes and said that the Maryland law was unconstitutional, making the National Bank, pay taxes. And so then the case went to the Supreme Court, and under Chief Justice John Marshall back then, he stated that they could not tax the National Bank or any other agency of the national government. So basically, a state can't come in and tax our national government, so, and the National Bank was part of the national government. So Marshall basically said the power to tax involves the power to destroy. So the court upheld the Constitution of the National Bank. So the power for a state to come in and tax the National Bank, they could destroy it. And they cannot destroy the National Bank because it's part of the nation, not just the state of Maryland. So it sounds like it's just like simple, and they should have known this, but they needed to go through the Supreme Court to make this case as a precedent to all other cases. So this came the doctrine of implied powers. The establishment of a national bank was necessary and proper. In our Constitution, it doesn't say any place that we should have a national bank, a federal bank. And so they said, in order for us to coin money, and make money, and to order for the government to tax and all these things, they're going to need a bank. So this gave forth the establishment of the national bank was necessary and proper in order for the government to carry out their express powers to do what the Constitution said, in the midst of that, not even in I say taxing necessarily, but in taking in money, for duties or all these things that they need to do, or in the midst of money, they needed to have a bank. So they said it's necessary and proper that we have a bank, that the federal government have a bank. And so that set forth in McCulloch versus Maryland, basically set forth the precedent that the United States government would have a national bank. Okay? Let's hope you got that. So since the 19th century, the necessary and proper clause has been interpreted more and more loosely by the court and Congress in a lot of different areas. So it becomes where that necessary and proper clause becomes where they can stretch things to certain bills and say, how does this bill, what we're doing, what does this have to do with the Constitution? So just remember, even today, the liberals will take necessary and proper and say about anything they can do, right? So we have to be very careful in this area, and that's in how the Supreme Court basically interprets either Constitution or non-Constitution, the necessary and proper. So powers reserved to the states. So let's go down. I'm going to go over this anyway. But the powers reserved to the state. The Constitution lists a few powers just for states and not for our national government. As the states must set the time, place, and manner of elections. So states come in and set what time they're going to have elections, the manner of elections. They may ratify amendments to the federal Constitution through the state legislature. And most important, the amendment for the state is the 10th Amendment. The 10th Amendment, and we went over that, the 10th Amendment that's, on the Bill of Rights, the last amendment says that any powers that are not named for the central government, that are not named here for the federal government, will be reserved for the states. So if it's not named in the Constitution for the federal government to do this, then the states will have those powers. That is actually taken for granted these days that we live. And the federal government has taken over powers that were supposedly for the states in many cases. But the Constitution basically said the states would have any power that was not mentioned in the Constitution. The powers not delegated to the United States by the Constitution, not prohibited by it to the states, are reserved to the states and respectively to the people. So let me see. That's what the 10th Amendment says. Let me go up here with the 10th Amendment. I think. Well, it's on the next page. We'll come back to this page. Right here, reserved powers. The 10th Amendment is about reserved powers. The powers not delegated to the United States by the Constitution, nor prohibited by it, are reserved to the states, respectively, or to the people. So the 10th Amendment declares that the states may exercise two different things. Number one, that the exercise of power, they call it the exercise of power, the power that has not been given to the national government, the power that has not been given to the national government is given to the states. And then number two, the states are not prohibited by the Constitution from exercising that power. So basically, the states are not prohibited by the Constitution in exercising the power. So those two things, and those are stated in the 10th Amendment. For example, the Constitution gives power to coin money to the national government, and the states cannot coin money. So that's already given to them. And the other, basically regarding marriage is it. The Constitution does not prohibit states regulating marriage. So no place in the Constitution it says that our federal government, our national government, can regulate marriage and divorce. But it does basically give the power through the 10th Amendment that states may regulate marriage and divorce. Because the power is not in the government and doesn't prohibit states from doing it, so they have the power to regulate marriage and divorce. So that's how those reserved powers go. So fulfilling obligation, but let's go back here real quickly. If we can. The division of powers here. So here's our national government. Here's the national and state governments, and here's just the state governments. Here's the delegated powers listed in our Constitution that the national government has. The power to coin money, the power to conduct foreign relations, to regulate interstate commerce, to levy and collect taxes, to declare war, to raise and support a military, to establish post office, to establish courts inferior to the Supreme Court, to admit new states to the Union. These are delegated powers that the national government can do. These are denied powers here. Denied powers are to tax articles exported from any state, to violate the Bill of Rights, to change state boundaries, to suspend the right of habeas corpus, to make ex post facto laws, can't do those, and to subject office holders to a religious test. So those things. Concurrent powers. Concurrent powers, both of them, to levy taxes and collect taxes and to borrow money. States have both. To make and enforce laws. They both can make laws. They both can establish courts, and they can provide for the general welfare and to chart banks and corporations, to have banks and corporations. Denied powers to both of them. They can't grant titles of nobility. They can't permit slavery. They cannot deny citizens the right to vote because of race, color, or previous servitude. They can't deny citizens the right to vote because of sex, right? Those things. Now, just the powers for the state government. For the state government to regulate interstate commerce, to conduct elections. States do that. They regulate intrastate, not interstate, but that means state commerce inside their state, not outside their state. Intrastate, not interstate. And to conduct elections themselves, to provide for public health, safety, and morals, to establish local governments, to ratify amendments to the federal constitution, to establish a state militia. They can have a state militia. Denied powers, they can't tax imports or exports. They can't coin money or make money. They can't enter into treaties. They cannot impair obligations of contracts. They can't abridge the privileges or immunities of citizens or deny due process, and equal protection of laws. So anyway, that's basically the division of powers between. This is really good. Just go back to here and you'll see everything on this chart. Let's see where I'm at here. Okay, let's go on. I know it's getting kind of long, but let's finish up here. So, fulfilling obligations. Fulfilling obligations from the Constitution. The national government to the states. Every state in the Union is guaranteed a Republican form of government. Each state has their own Republican form of government. The central government must provide the states protection against invasion and domestic violence, and must respect the state's territorial integrity. Equal representative in each state. So the national government's obligations to the states are what? The nation has to protect the states against violence and domestic violence. And that basically has to give that state a Republican government, and it has to respect the territory of that state that they have, and equal representatives in the Senate of each state. So those are the obligations. The obligations now that states have to each other. So states have obligations to each other. What kind of obligations? And this is stated in Article 4, declares 3 obligations that the state must have for each other. What are they? So they must have full faith and credit. They must have privileges and immunities from each state, and also be able to extradite, especially extradite criminals from states. So here's what the full faith. We're going to go over the full faith and credit. The full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state, and the Congress may by general laws prescribe the manner in which acts, records, and proceedings shall be proved and the effect thereof. So what in the world does this mean? Full faith and credit. Basically, full faith and credit is the act of one state honoring the civil laws and court decisions of the other states. So if one state has a birth certificate, gives birth certificates, then the birth certificate is going to be honored in other states. Or a property deed. If one state has a property deed that's issued, basically to honor that. Or a marriage certificate. Marriage certificates should be honored. If you go to another state, you're still married, right? So the Supreme Court exception was in one where a divorce wasn't granted by one state because basically that person went out of the state to get their divorce. So basically the Supreme Court upheld and said to reject the validity of a divorce granted by another state for a person who just went to that state to get a divorce, right? So that's the only exception they had. Otherwise, they're to honor any marriages or divorces or birth certificates and all these things between states. The second obligation there says that states have one to another is found in Section 2, that citizens of each state shall be entitled all the privileges and immunities of citizens in the several states. So if you're a citizen in one state and you have privileges, and in that state you go to another state, you would have those privileges too. So what are privileges and immunities? What are they talking about? So basically, when a state receives a citizen from another state, it must extend all any privileges that state has to them, as it protects a citizen from being unduly discriminated against because they're traveling into that state from another state. So basically the same privileges of voting, the same privileges as the other people in the state for hunting license and fishing license and all, that they'll have the same privileges even though they're coming in from another state. So a non-resident is also expected to obey all the laws and everything of that state while they're in that state. So privileges and immunities between states. So the third obligation, and this is in the second clause of Section 2, says a person charged in any state with treason, felony, or any other crime who shall flee from justice and be found in another state shall demand the executive authority of that state from which he fled to be delivered up, to be removed to the state having jurisdiction of the crime. So what does that mean? Well, by extradition, it means that you must surrender an accused or a convicted felon to that state from which he fled. So when a criminal wants to get away from the state, or away from the country, they flee, they run away. They're running away, they're a criminal, and for the state to chase them down, it used to be that states could not go into another state and make them come back because they were living in a different state. But this says they can. So extradition was that executive authority of the state with the responsibility of this. So prior to 1987, states were not required to do this. So if a felon or a murderer or whatever ran to another state and they felt they were safe there, the states did not have to surrender them there. And this actually happened. An example was in 1993. There was a governor in New York named Mario Cuomo was his name, of New York. And he refused to extradite a murderer. This murderer ran from Oklahoma all the way to hide in New York City. And so the government did not believe. He said, if we give him back to Oklahoma, Oklahoma has the death penalty, and Oklahoma is going to put them to death. And he didn't believe in the death penalty. So he harbored and said he can stay in New York. This criminal, a murderer, can stay in New York, and so that he would not be put to death. Well, what happened then? Of course, Governor Walters of Oklahoma stated the reason that Cuomo was opposing this is because he was opposed to capital punishment for murder. But then the new governor came in and repealed this and said, yes, we're sending him back to Oklahoma, and he was executed for capital punishment. So you can see now this means that any state, a criminal that runs from any state to another state, that state has to say, no, we're giving him back to the state that he ran away from. That's what it means. So let's go over the section review really fast here. Well, let's see. Yeah, I was going to go over it. Maybe I should stop there. I'm going to stop there because we're like 45 minutes long. So I'm going to stop there and we'll go do the section review. And I have another little section to go over. And then we'll start on the last section. This chapter 10 is very short.